So in 2009, as you retired from the Constitutional Court after 15 years at the court, your book, The Strange Alchemy of Life and Law, was published by Oxford University Press. It won the Alan Paton Award in 2010 and received high praise not just from judges and legal academics around the world, but people from all walks of life, including, as I understand, your babysitter. Now a French translation of Strange Alchemy has been published by Pretoria University Law Press, which is a wonderful opportunity to further expand the reach of your book. To introduce us to your book, could you unpack the central idea behind the title, The Strange Alchemy of Life and Law?
I loved it on the Constitutional Court. I had painful moments, very painful moments. We worked like crazy. I loved it. It was so special. It was so extraordinary. Marvelous colleagues, interesting ideas, big themes. And I wanted to share this. You know, sometimes you have a great experience and you want to run around and tell the world, hey, 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 look at this. You know, can you believe it? So in a sense, the whole book has got a can you believe it? But these were real experiences and full of surprises. So one of the surprises was, why was it so difficult to write a judgment? You'd think you got the facts, what the legal issues, the law, you apply the facts to the law and you get the answer. Why did I write 25 versions of one judgment? My secretary Fatima hid my judgment away. She said, Albie, you're not going to make a single other change. And I actually discovered, when I was visiting University of Toronto, some political scientists told me why it was so difficult. They said, Albie, there's a difference between the logic of discovery and the logic of justification. Click, suddenly it was there. Justification, that's reason. A, B, C, D, E, F, G, tick-tock, tick-tock, tick-tock. Discovery is random. And the heart of these difficult legal cases that could go one way or the other was that moment of discovery. Click, the apple falling down, the pieces coming together, the dots joining. And that's completely different from the rationality. I couldn't understand why all clever people, you don't get onto the court if you're not clever. Why do we disagree? Why do we fight so hard amongst ourselves? Because of these different random elements. And I wanted to convey that in terms of actual cases that we had. So it's not a legal textbook. It's not a book for lawyers to hold up and argue their cases in court. It's for people generally, judges, lawyers, law students, professors, human beings who, none of those things, to share with me something of that experience of being on the court. Passion. Passion, not I love you, I love you, I love you, but passion, emotion, empathy plays such a big role. And it's not just some vague kind of empathy for human beings being nice. It's central to the whole constitutional vision. Human dignity, that core of human dignity at the center of everything that we do. But passion can be anarchic. So it needs to be combined with reason. Reason can be sterile, it can be ugly, it can be used to justify the most ignominious things. So reason needs to be imbued with passion. So these two themes, how do they interrelate? The role of human dignity, proportionality, themes we'd never discussed at law school, never been asked an exam question, we never argued them in court. Now they're central to everything that we're doing. And how do we deal with terrorism and the rule of law, the combination between the two? What about the role of laughter in society? Does the law have a sense of humor? All these different themes now going through my head, sitting up on the bench there with my colleagues, I wanted to share them with a general public. And I didn't think I was giving away any secrets. I wasn't violating any confidentiality. I was sharing something that the public had a right to know.
I'm struck by how the structure and texture of your book reflects this alchemy or chemistry between life and law. Could you explain how the book draws out the resonances between narrative texts, such as your lectures, which have a very personal voice, and excerpts from judgments of both you and your colleagues from the Constitutional Court?
I had a sabbatical, went with Vanessa and little Oliver to New York, guest of the Ford Foundation, scholar in residence. I had 6 months packing together all my time off to think, to write, to allow the book to emerge. And I discovered 3 almost completely different sets of discourse. There's a discourse you have when you're writing a judgment. It's a very stiff way of writing. Maybe I opened up more than most of my colleagues did. But even then, it's got its cadences, it's authoritative, it's very, very serious. It's not fun or light reading, even when you're dealing with laughter. That's the one. Then there's the personal experiential, what it's like to be called a terrorist, what it's like to be a refugee, and now dealing with refugee law, and working in the underground, being locked up, subjected to torture by sleep deprivation, solitary confinement, stateless for many, many years. This kind of weird experience, bifurcated experience. Seeing the law as an instrument of terrible oppression. Rule of law meant rule by law. It meant Group Areas Act, pass laws, dispossession, disenfranchisement, and the law having a potential for something positive. Discovering that this divided Albie, the law professors on the one hand speaking about rule of law and justice, but they won't give their lives for justice, and the people in what we call the locations hating the law. The law was the police. The law threw them into jail. The law pushed them out of their little shanties and their homes. The law was the enemy, but they'd give their lives for justice. And suddenly the passion of the people and the great ideas of the ages of the professors come together in our Constitution. I wanted to convey something of that in the book, in its presentation. So each element had its own mode of discourse. I wasn't intending to be postmodern. I was actually pre-modern. I'm an old-fashioned modernist in terms of my imagination, 50s and 60s, and I loved, embraced modernism. So it wasn't a conscious decision on my part, but the chapters then are based on experience, reasoning, and judgments, judgmental texts from the judgments. It doesn't make for quick, light, easy reading, but I enjoyed writing it, and I think quite a few people have enjoyed the different, I think it's called palimpsests.
Yeah, absolutely. You write and speak very openly about how your life experiences have influenced or seeped into your judicial decision making. I'm interested in how this alchemy between life and law manifests itself at a collective level on the bench. So from your experience, how did the individuality and the diversity of your colleagues on the bench influence the nature or dynamic of your deliberations and your decision making?
It's something, it was very, very moving for me to be with colleagues, totally different life experiences. Laurie Ackerman used to collect wine labels, not even wine labels. You can't get a more refined, if you like, sophisticated hobby than that. Very cultivated, very deep thinker, profoundly religious. His wife, professor of liberation theology, the first woman to wear jeans at Stellenbosch University. A personality, a character. Johan Krechler, son of a military person, diplomat, very learned in English, Afrikaans, very sensitive nature, deep cultural appreciation. Maybe growing up as an Afrikaner in an English environment made him sensitive to African cultures and other community cultures. And so I could go through Yvonne Mogoro, growing up in Galeshebwe in Kimberley, very poor family, and encouraged by Robert Sobukwe to become a lawyer, and discovering herself on the bench. Who, me? My voice is equal to all these giants? And introducing Ubuntu into our thinking, because she lived Ubuntu. Kate O'Regan, fast-talking, quick colleague, brilliant, sharp, soft voice. We couldn't keep up with her. And so thoughtful, so principled. You know, I could go on. Ishmael Muhammad, soaring into outer space with lyrical phrases and deep passion. And he'd suffered such indignities and humiliations imposed upon him as an advocate through the law. So these life experiences now come together on the court. Pius Langa, one day I'm with him in Durban, at the Queenie, and we pass a building. Albie, that was the native pastoral building. When I was 16, I had to go there. They stripped me naked, felt my testicles, hosed me down. I didn't like that, but you know, you're young, that's life. You can't get a job without a pass. But to see men old enough to be my father being subject to that I couldn't bear. Now that goes to human dignity, why we need human dignity, not just a beautiful ideal to satisfy some philosophical principle, something to deal with the pains, the injustices, the hardships experienced daily and still experienced daily in the lives of our people. So if these things don't come into your understanding of the law and its impact and how to interpret it, then you're failing. It's not an add-on. It's not something you do for the newspapers or a headline. It's something you do because it touches on the deepest part of your thinking as a judge, as a human being, as a citizen, as a person, as a lawyer, as a thinker. That's the way you have to tell the legal story. It comes in very spontaneously and naturally.
But this idea that one's life experiences really seep into your judicial philosophy, your thinking, and your reasoning as a judge entails an acknowledgement that adjudication is not value-free, it's not neutral. And of course you'll be very well aware that in recent times there's been an increase in very personalized attacks on judges for their decisions, saying that judges are biased because of who they are, their identity, their life experiences. So how would you respond to that critique? On the one hand, acknowledging that decision-making is a balance between reasoning and passion, as you put it, these different kinds of justification and discovery. But how do you respond to that acknowledgement? Does it mean that judges are not impartial, that we can't trust their decision-making?
Okay, for me, what's central is the distinction between neutrality and impartiality. If you are neutral as a judge, you fail as a judge. Our Constitution is not neutral. Our Constitution takes a stand. It doesn't say anything goes. Our Constitution demands a non-racial, non-sexist society. You can't turn a blind eye to racial discrimination. You can't say patriarchy doesn't matter. It deals with sexual orientation. You can't say these things don't count. They're there. They were agreed to by the people through their representatives in Parliament, sent there to draft the Constitution with a mandate from the nation. binding on the judges, requiring the judges to take a stand to uphold the Constitution. That's the oath we swore. The oath is not to say we're going to ignore the Constitution, we're going to be neutral on those issues. Impartiality means something quite different. It means you listen to everybody, you take everybody seriously, you give everybody a chance. You don't start off with a predetermined position on any case that comes to you. You listen, you hear with open minds to the arguments and the debates. That's absolutely vital. I happened to have a lunch one day in the Supreme Court of the United States, and 6 of the 9 judges were there. Cuisine, very sparse, conversation fantastic. And the first question put to me was from Justice Alito. Justice Sachs, would you say yours is an activist court? And I said, Justice Alito, it is an activist court. We have an activist constitution. It's a very activist constitution. It's not a neutral, bland constitution. It's not just a set of institutional arrangements and then leaving it to Parliament to fill in all the gaps. It's very value-laden, and you're expected to respond to that. Life experiences can work in different ways. In my case, I was blown up, I lost an arm. Security agents of apartheid did it. I could have ended up angry, bitter. I don't know why, but I didn't. For me, the response to that experience was never again. We don't want these things in society. We don't want brutality. So the experience itself is not so significant. It's how you interpret the experience. We had a whole generation of judges who'd fought against Hitler. To say that that was completely irrelevant to their work on the bench afterwards would be absolute nonsense. Robert Jackson, the great American judge, was at the Nuremberg trials. It came into his reasoning on the Supreme Court afterwards, and appropriately so, for the law, for the law. So the issue is not are you subjective, but is your subjectivity encased by or filtered by the prism of the Constitution? And it's that prism of the Constitution that enables somebody who's secular, I happen to be secular, to reach exactly the same conclusion as Laurie Ackerman, who's deeply religious, the other colleagues of mine. It's not their scriptural views or interpretation that come through, it's their legal interpretations as human beings who happen to be deeply religious. My legal interpretations based on a different worldview, philosophical worldview. We meet, we come together. And I see that as a source of richness. We're not all cut from the same cloth. We in that sense, we cut from very different materials, but they all weave together to create the tapestry that provides, at best, brilliance, at worst, at least, some color and vibrancy to the work that we do.
Could you tell us what inspired the publication of a French translation of The Strange Alchemy, and what is your hope for its impact and reach, particularly on the African continent, but of course beyond too?
The translation was triggered by something completely extraneous. I've become very friendly with a family of Jan de Groof and his wife Christine Skuurmans in Amsterdam. They stay with us, we stay with them. And Christine was having some problems with the judiciary. She stepped down, she had time on her hands, and she said, Albie, I'd love to translate your book. She's French speaking, but living in a Flemish speaking part of Belgium. So she translated the book, and then the question was who to publish. And pulp came onto the scene. And that thrilled me no end, because the idea of the book, great, if French speakers in Belgium read it, I'll be only too happy. It's got a short introduction by Claire Leroux de Bay, brilliant, marvelous Canadian Supreme Court judge from Quebec. Great if it sells over there, if it's read over there. But Africa, Maghreb, West Africa, Central Africa, lots of lawyers and law students and professors and debate. I'm sure they're having many similar problems. The idea of being able to share South African experience with them was just very exciting for me. There is one other international language into which my book has been published, and that was Portuguese. So it's been brought out in Brazil. And now it's not just Brazil and Portugal, and the Portuguese-speaking countries in Africa, Portuguese is spoken, but the idea in Senegal and Rwanda and Tunisia, the book can be read and we can exchange ideas. I find that very, very exciting.